Good morning. I am Jonathan Lee, and I'm a member of the CBA Board of Directors. On behalf of the Contra Costa County Bar Association, I would like to welcome you to the 27th Annual MCLE Spectacular. We hope that you are feeling updated, up-leveled, and uplifted. This session, titled How to Get Past the Impasse, Effective Use of Persuasion and Influence in Mediation, with speaker Stacie Hausner, is presented by the CBA ADR section. A couple of quick housekeeping items. First, the materials and evaluation forms for this program can be downloaded from this session page through the Files tab above the chat. Second, your attendance certificates will be available after the Thanksgiving holiday. For further information on how to access them, please see the FAQs tab on the event's main page. Third, for assistance with any technical difficulties, also head to the FAQs tab on the event's main page. Don't forget, while this program is pre-recorded, the speakers are available live in the chat to answer your questions during the presentation. They will also be available in the live Q&A immediately following the presentation. As a reminder, our event and program sponsors are a very important part of our CBA community. They make it possible for us to provide events like this. Please support us by supporting them, and please take time during the spectacular to visit their online booths. At this time, I would like to pass the program to Palveer Shoker, the ADR section president, to introduce today's speaker.
Thank you, Jonathan. And I would like to join Jonathan as well in welcoming you to Contra Costa County Bar Association's 2021 MCLE Spectacular. My name is Palveer Shoker, and I'm the ADR chair. We are continuing the ADR section's long-standing tradition of bringing some outstanding programs to you during our MCLE Spectacular. I am extra excited today to introduce our speaker, Ms. Stacie Feldman-Hauser, for today's program on how to get past the impasse in mediation. Ms. Hausner is a mediator with ADR Services, Inc. She has successfully mediated over 700 cases in various areas, ranging from business, personal injury, employment, real estate, construction defect, and entertainment law. Ms. Hausner also teaches at Mediation Theory and Practice and Advanced Mediation as an adjunct professor at Pepperdine University School of Law, and has also co-taught the mediating the litigated case at Strauss to judges and attorneys becoming mediators. She also teaches and trains mediators at the Central District Court panel and frequently presents MCLE programs to lawyers and mediators. And, she has been successfully able to pivot her mediation and teaching practice over to Zoom in the last couple of years. And I am so glad, and we feel fortunate that we were able to get into her busy schedule and snatch her for this program. And before I forget, just human, I'm sure I'm forgetting a lot of Stacie's accomplishments. So I encourage you to please visit her website, staciehausner.com, and just read about her resume. You'll be impressed. Without any further delay, Stacie, take it from here.
Well, thank you so much for that kind introduction. Those words are so wonderful. Thank you. And I'm very excited to be here with you all. I will be talking today. I'm pulling up my share screen. Give me 1 second. We'll be talking to you today about getting past the impasse, how we can effectively use persuasion and influence in our mediations and settlement discussions. So let's get started with that. This presentation, we're going to cover how mediators and negotiators can influence people to move towards settlement. And we're going to look at this through a psychological lens. We know that people have cognitive biases that can interfere with settlement. So we're going to take a look at some of those most prevalent in a mediation or in a settlement discussion. And we'll discuss ways that we can help prevent them from creating an impasse or disrupting our settlements. And then the second half, we'll switch focus and we'll talk about some techniques of influence and persuasion we can use to get people to accept settlement results, to get people to walk with us towards settlement. So we'll be covering both of those today in this hour I have with you. So let's get started here. And we'll start by talking about heuristics and cognitive biases. So there have been decades of research research that's been done by cognitive psychologists and behavioral economists about how we make decisions. And we know that our brains process enormous amounts of data every day. We're making millions of decisions. And because we don't have the mental capacity to go into a deep dive analysis when we're making these decisions, we often do mental shortcuts, and we call these heuristics. And these are fantastic most of the time because they help us navigate the millions of decisions we have to make. So let me give you an example. If you're going to brush your teeth in the morning, you don't need to put a lot of mental thought into, taking the cap off of the toothpaste and putting it on your toothbrush and how to brush. You just automatically do it. Another example would be when you're driving to work. How many times do you just get there and you didn't even think about it? You're just at work. These are the type of shortcuts that our brain makes. We also refer to gut reactions or impulses. Those are these heuristics, these short mental shortcuts, not diving deep into any analysis. And again, they're fantastic much of the time. But cognitive biases occur when we really should be slowing down our thinking and doing a deeper analysis. And instead, our brain is doing this quick thinking heuristic. And cognitive biases form, and they're predictable errors in rational decision making. And they're based on assumptions and inferences common in heuristics rather than this slowed down analysis. Now, cognitive biases are heightened by emotions. And when people are involved in a dispute, they often have heightened emotions. So we keep that in mind, that we see them a lot when people are in conflict, and particularly strong when we're in settlement discussions. So they're problematic because they don't allow us to consider new information or accurately assess risk, and therefore accurately evaluate a case for settlement. And so what do we do when we see these cognitive biases interfering? So today we're going to talk about there's hundreds of them that exist, maybe thousands, but we're going to talk about those that are most prevalent in settlement discussions. And the reason we're going to discuss them is we don't want them to interfere. We don't want them to create an impasse as we're trying to settle a case and negotiate a deal. So let's take a look at those that are most prevalent. I'm going to first discuss the ones that prevent us from considering new information. And that's important because as mediators and when we're negotiating, we're trying to get people to understand another perspective so that they can move their evaluation of the case closer to those of the other participants. And when they can't consider new information, it gets harder to do so. So let's talk about those cognitive biases, the four that most interfere with the ability to consider new information. And the first one is called confirmation bias. And that's when a negotiator evaluates new information in a way that reinforces their pre-existing beliefs and ignores or devalues information that goes against those beliefs. Another word for this is cognitive dissonance. People are very uncomfortable taking a position that contradicts an earlier position taken. And an example of that would be, a current example would be the vaccine. If you are against taking the vaccine and you have all these reasons to support why you're against it, it would be very uncomfortable to consider new information and change that position. We are taught this in law school, and this is kind of what litigation and trial is about. You discount this other side's arguments and evidence, and you heighten and emphasize those that confirm your position. Another thing we may do is engage in selective listening. So if it's evidence that goes against our position, we may kind of hear it, not hear it so much, and really emphasize that information that confirms our previous views, okay? And this is what happens when you're in a settlement discussion. If somebody entrenches in a position, it gets hard to get them to change their mind on that position. If they know they're right, all the information that's coming in to suggest otherwise is discounted or disconfirmed. And so that's our first bias, this confirmation bias. Selective perception and selective memory are similar. And that is when a negotiator only sees information that validates what they think they should see and only remembers the information that validates their position. So if they think they entered an intersection when the light was green, any information to suggest otherwise will be discounted. They'll remember very clearly the light being green. That's the selective perception and selective memory. An example of this, they've done a lot of studies on this. One example is if a teacher has a favorite student, they'll ignore all the behavior that would suggest disruptive behavior and only see the positive behavior. They also did studies where they told a bunch of teenagers there was alcohol in a punch bowl. And even though there wasn't, all the teenagers started showing signs of motor impairment. So that's how strong of an impact this selective perception and selective memory cognitive bias can have. The next one is reactive devaluation. And this is when somebody discounts an idea or maybe a settlement proposal because it comes from the other side, their opponent. This is a very easy one for us neutrals to counteract because we can just frame the information, the ideas as coming from us. So instead of saying, look, John over there has a great idea. He thinks that you should sell widgets exclusively in Canada and he'll sell widgets exclusively in Argentina. Automatically, the other side would be suspicious because this is coming from John and they're opposite John in litigation or in a dispute. Instead, us mediators, we can say, look, I was thinking that maybe we could have exclusive distributorships. What do you think about you having an exclusive distributorship in Canada and maybe John take an exclusive distributorship in Argentina? They would be more likely be able to hear that because the idea is originating from me rather than the other side. So this is an easier one, and we're going to get more deeply into tools we can use. But this is a more easy one for us neutrals to counteract because we have the power of neutrality. And we have to use that power often in a mediation to get around some of these biases. And fourth one is fundamental attribution error. And this occurs when someone attributes a decision to the character of the person making the decision rather than the external circumstances. So you'll see that if an insurance company is offering $100,000, the plaintiff may say, look, they're offering $100,000 because they're stingy and they lie and they just want to take our money. And you start attacking the character of the person rather than looking at the facts of the case. Maybe they're offering $1,000 because that's the value of the case. And so they get in their head about attributes. Somebody's a liar. This is particularly strong when somebody feels their trust or loyalty has been violated, a breach of fiduciary duty type of case. But you see this oftentimes in a conflict where they have such bad feelings towards the other side that they attribute value based on characteristics rather than the circumstances. All right, so what can we do when we notice these biases that interfere with somebody's ability to consider new information? So let's talk. We want to slow down the analysis, right? Because we know it's a cognitive bias, and cognitive biases are formed by fast thinking rather than a slowed down analysis. So how do we do that? The first thing we want to do is ask the right types of questions. If we're asking yes, no questions, we're going to trigger these cognitive biases because that's that quick thinking. It's very easy to get defensive. Instead, we want to ask open-ended questions, right? What happened on the date of the accident? How has your life changed? What are your goals? These are great questions anyway at probing for underlying interests and looking for creative resolutions. That's a whole nother conversation. That could be an hour in and of itself. But if we are going to ask yes, no questions, we're triggering quick thinking. Also, if we come in and we do a direct attack, it's going to trigger it. So instead of saying, you didn't do this and you should have done that, as mediators, we want to ask questions or say, the other side's making a big deal about this. We need to come up with a response or how can we explain why you didn't do X, Y, or Z? We don't want to come into them with an attack. because an attack will trigger defensiveness. So questioning is a great tactic to avoid these types of cognitive biases rather than a direct negative statement. Another way to slow them down is ask them to summarize their positions. Ask them to what the other side will be relying on, what evidentiary support they have for the various positions, both theirs and the other side. In doing so, that will slow down their analysis, kind of get rid of some of that quick thinking defensiveness. Another thing is giving an audience to their story. And we're going to get into this a little more in some future slides, but letting them know we care about what they have to say, what they need, questions, how can I help you? What do you need? What information do you need? Those types of questions will slow down an analysis, get rid of some of that defensiveness. Just to give you a few categories of questions. So as a mediator, I am able to orchestrate the conversation and choreograph the conversation by what questions I ask, what I choose to focus on, how I choose to frame the conversation. And visually, I like to think of it as a long hotel corridor with lots of doors. And I get to choose what doors I open and what, I may peek into this door, ask a few questions, say, uh-oh, that's not great for settlement. Quickly close the door. Go into this door. This might be a good area and productive to settlement. This may give me some information that can be helpful. So I'll hang out in that room for a little bit. Then I'll close that door and continue down the hallway. We get to choose what questions we ask. And so keep that in mind. It's very important because that focuses people's attention. That gets them to focus on the issues we need them to focus on to move them towards settlement. So one type of question is the information gathering. These are the open-ended. What are your main issues in the case? How has your life been affected? What are your goals here? Goals are very good for creative resolution. What do you think the other party's missing in their analysis? That's good to slow down thinking. Problem-solving questions, these are great. These are forward focus. What would happen about a future relationship? What information do you need to get off that number? Any ideas for creative settlements? That's problem-solving questions. Reality-changing questions, these are great too. Regardless of who wins, we do this a lot in the closing phase. How long is it going to take to get to trial? What lost opportunities are you going to have? How much is it going to cost? What will you net if it costs this? What's a great verdict look like? How much are you going to net? These are reality-changing types of questions. They're effective as well to slow it down. Also good questions to get people towards settlement. And then I love the hypothetical question. This is when you create some worry in people that they may not have. So what will happen if your star witness doesn't show up for trial? You had mentioned that right now they're in China. What if they don't want to come out here? What if they can't come out here? How are you going to prove your case? So we can do this depending on the substance of your dispute. We can create some concern with these hypothetical questions. When people are very triggered and defensive and contrarian in their responses, and all of us mediators have had that sometimes where we can't even get out a sentence without them interrupting, say, but that didn't happen, or that's wrong, or, when they're very defensive and we can't change that focus or get in to the cognitive bias, we still can settle the case, move forward, focus to solutions. Solutions are great anyway. And when I teach at Strauss, I teach both mediation theory and practice. I also teach advanced mediation. We talk about talking about solutions as quickly as possible. It avoids the competitive arousal common in the defensive cognitive biases. It can create collaboration. Let's brainstorm. Let's talk about solutions. It diminishes reactive devaluation in doing so, gets us off that fundamental attribution error, because now we're thinking, how can we get this resolved? We don't need to agree on facts. I oftentimes will say, that's going to be difficult for a jury. I wonder which way they'll decide, if we have a factual issue and I can't get anywhere with that. We can still resolve the case. Also, it allows people to stay consistent with their position. So I mentioned cognitive dissonance. It's very uncomfortable to contradict a position you earlier took. I never say to someone, so you admit you were wrong there. I mean, I wouldn't do that in a personal dispute. I wouldn't do that in a mediation because that's very uncomfortable. We can tell they're quiet or they don't respond or they change their number and start moving towards settlement. We don't need people to have to say it or feel it. So we want to allow people to stay consistent with their positions because it's uncomfortable not to do so. So focusing on solutions, moving forward and off of it is a great strategy so that the cognitive biases do not interfere with settlement. Another thing we can do is when they're disputing all the information coming in and they just can't hear it, let's use good information. Objective raw data and verifiable facts are much better. So instead of me saying, yeah, if you sell the car, you could sell for $20,000. Let's show them Kelley Blue Book value. That's going to be a lot more compelling than me saying it. If I say, yeah, the client said this in a depo, if I have a depo transcript, it's going to be much more persuasive than me just saying the person said it. Typically, lawyers know what was said in a depo, but in case that lawyer wasn't there or is late to the case, something would be more compelling. Same with photographic video evidence. In an accident case, if the plaintiff says, I no longer can play tennis, and the defendant has a photo or a video of them playing tennis, obviously that's more compelling. Also, comparative verdicts can be helpful, or analogous situations are helpful. Sometimes people who are strongly cognitive biased cannot hear the information when it's in the context of themselves, but they can consider information outside of that. So telling a story about something that happened to someone else or a similar settlement or comps, I think of real estate comps with both leases and purchase prices of property. These types of things can be more easily heard than in their own context. So keep that in mind when you're sharing information. Let's get good information. Using visual aids, that can slow down the analysis. I've loved them in my mediation. So sometimes I'll put on a board more in person, but now we have, even on Zoom, we have a white screen we can use where you break down the damages, you break down numbers, you can even break down risk with decision trees and whatnot. It doesn't matter if you're using numbers they like or don't like. What's important is that they slow down and help you create new numbers. So I've oftentimes, when I'm working with different caucuses and I leave someone's room, I'll leave them with a homework assignment. Can you find me this or can you find me that? Or I'll tell them, can you rework these damage numbers to what you think would be fair? And then they'll come back and they'll have reworked it. Now they've slowed down their analysis. I often get participation from the actual client or the party to the dispute, not just the attorneys, and they're working slowly with the information. If they're working with me on it, it's great too. We can work together on getting numbers that they're comfortable with, but a visual aid can be very helpful. It objectifies the information, it slows down the analysis, makes it easier to consider. Okay, so oftentimes I try to prime the parties right at the opening, right at the outset of the mediation, so that they don't entrench in a position. Because I know the second they entrench in a position, they're going to have cognitive dissonance. It's going to be hard for them to contradict that. So at the outset, I try to get them engaged with the process. I tell them, look, I know it's going to be hard when I come in and I'm sharing their perspective and the information they gave me, especially when you know it's not true, but it can be very valuable to listen to what they're saying. You can use it as you prepare for trial should the case not settle. And then we can work together in creating a response. Start is a good trust and rapport building technique that I'm going to be working with them, not against them. That's very important. If they're combating me and fighting me as a mediator, they're going to entrench, they're going to have cognitive biases. It's not a good method to get people to settlement. We want to work together with each side so the other sides can understand. I also usually tell them that their attorney's going to take a different role, that the attorney's not going to be a gladiator like they're going to be in court. In court, they're going to fight everything that's said. But in the mediation, they're going to evaluate the case and look at the strengths and weaknesses and the risks at trial. And I do that because I want to prime the attorneys to do so. But I also do it because I want the client to know that this is a different role. So I tell them, we'll work together. We're going to work slowly. If we're working together, that's great. I'll slow down the analysis. And I get the lawyer working as a collaborator and get them to be patient and a slower analysis. So I think it's good to even mention this right at the beginning. I encourage parties to share mediation briefs for several reasons. I think it enhances their position at trial. By doing so, they can share the information with outside decision makers. Not all the time do I have a decision maker in the mediation. I try to. I have pre-mediation conferences asking decision makers to be there. But sometimes somebody has a dad who's a lawyer or a spouse who's a lawyer and they want to run it by them. If we get them a mediation brief, they're going to see that right at the beginning. Additionally, I know cognitively biased people, if they're hearing an argument for the very first time, especially if it's late in the litigation, they're hearing it from the first time from me, they're going to discount it. But if they see it in the brief and they have time to slow down and think about it and think how they want to find evidence to contradict it, whatever that may be, they've heard it, they've slowed it down, they've analyzed it, and they've considered it in even their initial evaluation of the matter. So I think it does a great service to attorneys to share mediation briefs. I know some of them don't want to. I don't force them to. If I notice someone's very cognitively biased in the mediation, I'll even ask mid-mediation, while I'm working with you, can we get them your brief? Let them slow it down a little, take out whatever you need. And lawyers don't need to put everything in the brief. They can keep out their smoking guns and their, conversations about settlement. But if they get them the basic arguments, typically they do a really good job with these briefs. So I think it can be very helpful. As a mediator, we have to use our neutrality. I talked about it when I was talking about reactive devaluation. So we originate ideas from us. We can ask questions rather than frame it as they say this and they say that and get them all riled up. We can say, what are we going to do about this? What are we going to do about that? That's a softer, easier way for someone not to be defensive. We make our communications positive. That's a basic. We're going to take out all the toxicity and name calling and only communicate things positively towards settlement. We can frame to change the focus on different issues. We're going to ask thoughtful questions. And I always say, we should find a response. We should work together to respond to this. What information should I try to get for you? I am not fighting them. I don't want to fight them. I try not to fight them. I try to work together to make it productive. And if we're working together and I'm on their team, they're not going to feel the need to be so cognitively biased and combative. So I love this slide, not because of the graphics of it, because it's very simple, but because it is very, very important that we build trust and rapport as mediators. And if you're negotiating without a mediator and you're a lawyer looking for negotiation skills, this is very important. They have done tons of studies and they've done in the mediation context, what is the number one factor that gets people to settlement? And they have found that it's trust and rapport with their mediator. Okay, it's not how smart their mediator is or how much their mediator knows about the subject matter. It's how they connect. Do they trust the mediator, move them to settlement? And do they connect with and to hold their confidences? And do they trust the mediator to convey information? And do they trust the mediator to convey their offers and demands? All of that is much more important. So building connection is key. If you're negotiating without a mediator, you want to build connection also. Let them know you hear them. Let them know you appreciate any movement. Let them know you're considering their needs when you're trying to find a solution here to the negotiation. all very, very important. We are going to talk about influence and persuasion. You will see these are top items for those behavioral economists as well. Building unity, building connection, getting people to like you. All of that is trust and rapport. It is very, very important in a negotiation that you connect with the other side. In mediation, it's not as important. It's important to connect with the mediator because we're the messenger. We're the one they're interacting with. So if you're doing caucus, which in LA, that seems to be the preferred method, we don't really do much joint session. I'll do it if they agree to it mid-mediation to get past an impasse. But typically everyone wants caucus the whole time. So they need to connect with their mediator. But if you're resolving a dispute without your mediator, please keep in mind, you got to figure out how to connect, how to get them to like you. Certain trust and rapport building techniques we can use. One is empathy. It's very important as mediators and negotiators build empathy. Now, empathy is not, if somebody said, I'm really upset my daughter is failing geometry, you wouldn't say, well, your son is getting an A in algebra. And if they say, I'm really upset, I'm fighting with my spouse, you don't say, well, at least you have a spouse. That would not be good empathy. Do not do that. Instead, you want to put yourself in their position and let them know you're here for them, that you hear them, that you will listen to them and try to understand, all that nurturing, loving type of behavior that you would give. People share information and trust you if they know they care. Sharing is caring. That's what I used to tell my kids when they were little. Sharing is caring. So we want to show empathy to their position. We want to validate what they're saying, give audience to their story. If I had been fired because of my age, I'd be upset too. I get it. People want to hear that validation. Even if they're telling us some crazy story, we want to validate it. We want to give audience to their story so that they can walk with us to settlement, so that they trust us. It's all that good active listening skills, questions, so that you get to choose how intimate you want to get, but ask questions so they know you're interested in their story. Great trust and rapport building techniques. And remember, you need trust and rapport if you're going to settle a case as a mediator, and you need trust and rapport if you want them to trust you and brainstorm and work towards a resolution. When you can't get past anything else, one thing you can do is appeal to emotions. That is dicey, so I say do so with caution. But John Bargh wrote a book called Unconscious Influences, and he talked about the importance of this, of appealing to emotions. And he said people don't like to feel sad. They want to change their state when they feel sad. So I remember that line, and sometimes I'll ask questions to evoke some sadness. Asking them to relive what happened, tell you about how their life has been negatively impacted by an incident or an accident. Things like that often will create some tears and emotion. That's not a bad thing. You can then bring that up later. I don't want you to continue to suffer. If we can get you a deal, you could be done with this, move on finally with your life, things like that. So emotions is a good thing at times to bring up. You don't want to allow it, venting can help. Once people vent, they can move towards settlement. Studies have shown that. So let them vent on you as a mediator. Sometimes it's hard for the other side to let them vent. But if the other side's able to do something like that, and you can coach for that, I'd get a feel for that before I'd stick someone in the room with somebody who needed to vent. I'd make sure they could handle that. The other thing I say is, we are somewhat, I think of it kind of as an analogy to grief and loss. People have high hopes when they come into a litigation. They may think they're getting $5 million when they start litigation. And now things aren't going so great. So now maybe over a course of time, they've adjusted and they're expecting $2 million. And they get to the mediation and they're learning, look, you're not getting 2 million. At best, you're going to be getting 1 million. This is difficult to process, and they need to process this loss. They did studies of shipwrecked loved ones, they didn't even start grieving until they were certain this person wasn't coming back. As long as there was hope, they never grieved. And in a mediation, this may be the first time there's no longer hope, and they've got to accept a number or a resolution they weren't ready for. So we need to be patient with that. We need to let them grieve that and make it part of our process. So emotions can be very important. Some mediators want to avoid them. Sometimes we don't ever need to even get into them. We can get cases settled. But sometimes we may want to use this as a tool. So just keep that in mind with your particular dispute. Is this somewhere you're comfortable going? Is this somewhere that can be, do you need to go there? Can you be successful if you do go there? So just something to keep in mind with your own practice. Okay, so that's the cognitive bias. That's tools, for these cognitive biases that impact an ability for somebody to consider new information they need to, make concessions and move towards settlement. But there's other cognitive biases that exist that impact settlement. So let's get into those. The first one is optimistic or judgmental overconfidence. And this is when people give themselves much higher chances of succeeding than actually exist. And they look at this, for example, at horse racing. If you make a bet on the race, you think your horse has much better odds of winning than they actually have. Lawyers do this. They're overconfident because they're involved in the case that they're going to win at trial than their actual chances are of winning at trial. And people who are experts tend to even be more overconfident. So lawyers who are experts in the law, especially to their client, tend to be overconfident. What do we do about this? The problem with it is they're not potentially accurately considering risk and therefore not evaluating their case similarly enough to the other side. So one thing we can do is we can ignore it and change the conversation. Remember, we get to choose, we choreograph the conversation. We could talk about how risky trial is. All trial lawyers will tell you they lost some that they thought they would win and win some that they thought they would lose. So we can talk about that. We can talk about decision makers and the risk that the jury comes with their own headset, their own past experiences. Maybe they're a landlord, so they're going to favor a landlord. Or maybe their sister just is a tenant who's getting screwed over by that landlord, so they're going to automatically be pro-tenant. Maybe they have implicit biases. There's a lot of literature on this now that they don't even know they have. Maybe they don't like people named Paul because the bully in third grade was named Paul, and your client's name is Paul. We just don't know. So I talk about some of that with the risk of a jury and a decision maker and how great settlement is because you're the decision maker. I talk about that at the beginning. In my opening, I talk about it as I'm trying to close a deal and the risks and my worries about taking the risks. So that's one. These are ways, and you can think of one specific to the substantive matter in your dispute as well. Sunken cost bias, that's throwing good money after bad. People come up with subjective valuations of their case. A plaintiff will decide my case is $1 million, and then they'll add on their attorney's fees. And a defendant will say, look, this case is $100,000, and they'll subtract their attorney's fees. And now we have a bigger chasm between the two sides. And it can interfere with settlement because the make whole number is now impacted by past money spent. What we can do is, talk about not throwing good money after bad. We wouldn't want to call it that, obviously, but to get them forward focused. How much is it going to cost to get through the dispositive motions, to finish the discovery, to get through trial? And then how much do you expect to get at trial? Okay, so we got to subtract that number from your outcome. Can we get more net to the client now than if we spend all this money to get through trial? So we'll talk about future expenditures, and that can be beneficial. Risk aversion and loss aversion has a huge impact on settlement. And I think they've done studies that have shown loss aversion is the number one obstacle to settlement. So let me just start by saying we all have different levels of aversity. I am very risk averse. I don't go to Vegas and gamble. I don't want to, I'm so nervous about losing that money. I don't take a lot of risks. It's not in my personality. I have friends that take tons of risks. I have people in mediations that love risk. But people in general would rather take a sure thing over a gamble. And that's fantastic for us mediators because we can sell settlement as a sure thing, right? Trial's a gamble. We have these decision makers that come with their headsets and their biases, and this is a sure thing. So if we can get them in a reasonable range of settlement, they're likely to settle. 95 to 98% of all cases settle. So that is why. And we can sell it, and we should sell it as mediators. And you lawyers out there should be thinking about that as well. The problem is people are loss averse also. They're 4 times more loss averse than risk averse. And that's they rather take a gamble over a sure loss. And that can be problematic if a defendant sees this as a loss. Look, I'd rather gamble it than pay $500,000 right now to settle the case. So we mediators, we got to frame this and get in their mindset. We got to look at things as a gain and frame it as a gain so that they see the gamble as trial and this money as a gain. So if the plaintiff was at 2 million and they're at 500,000 today and only today, look, you've made $1.5 million today. Well, let's look at that. And we're talking about how the gain is. Brackets, some lawyers hate brackets, but brackets get people into a reasonable range where they say, okay, look at all this movement I've gotten today at this mediation. This feels good. This feels like a gain. If we can't really do that with the numbers, we can add creative terms and muck it all up so that they can't tell if it's a gain or a loss. Look, they're only given 100,000, but they're offering to give me a future contract or right of first refusal or a different piece of property or whatever the creative resolution, roofing services for the next year, whatever the creative may be. Maybe you can't really determine value, and us mediators can sell it as a gain. But at the end of the day, keep in mind, people have to go home to their spouse or their boss or their colleague and justify choosing to settle, justify, putting this dispute behind them. And they need to feel gain. Maybe it's an emotional or psychological gain, but it has to feel like a gain. It has to feel like a win for them to accept the deal. So we should keep that in mind as mediators, as lawyers. If you're negotiating without a mediator, sell to them why this is a good deal for them. Anchoring bias is a biggie. Mediators, lots of lawyers know about it. It's really that people look at numbers in relation to earlier numbers used. And the earlier numbers can have nothing to do with the reality of the situation. You could they've even done studies. You could spin a roulette wheel. It'll land on a number and it will impact somebody's decision on what the value of an antique is. If it's a high number, they'll go higher than if it were a low number. So a lot of people know this. Marketers, business, salespeople, they know it. They'll say, sweater, $100 on sale for $50. They know you're more inclined to buy that sweater than if it just said sweater $50. Realtors know it. You'll say, I'm looking for a house for $1 million. I'll take you to all these houses for $2 million. So when they show you the $1 million house, you're like, yes, this is a great deal. So people know that. Lawyers know it, and they'll want to anchor really high or really low in a mediation. That's that first number. And they know, they say, look, I want to create an expectation that this number settlement is going to be high, and I want to use this to anchor to. And that's great. I mean, there's some value to that. So I always say they need to find the sweet spot. It needs to be extreme enough that they have room to make concessions and set an anchor, but not so extreme that the other side is insulted or wants to walk away or engages in negative negotiating behavior. You're trying to get as much as you can from the other side. So if you're going very extreme and insulting, you're not going to get much from them. So you got to find this. Lawyers have to find the sweet spot. As mediators, we can help them find the sweet spots. We can coach them if they're interested. If we've connected with them, they may ask us. They may not ask us, and we may want to try to get them off the number by saying, how do you think the other side will react? What type of number do you think they'll come in with if you come in with this number? If we can't get them to move, we may want to ask them to attach it to damages so we can explain it to the other side. That can be helpful. We may want to add creative terms. So maybe they're only offering 10,000, an employer saying, I'll give 10,000 for this wrongful termination dispute, but I'll give them a job in my Arizona office, or I will write a positive recommendation, or I will make a referral to my friend at this company. This is a great fit for this person. There's no value in that. I mean, there is value. It just can't be measured by a number. And so that's a good way for us as mediators to, counteract some of the anchoring effect. If I have to deliver an insulting anchor, I'll tell the recipient, don't worry about it. Cases settle at the midpoint of the first reasonable offer and the first reasonable demand, not at the midpoint of anchors. And they've done studies to show that the person who comes in with the first reasonable number has a negotiating advantage. So I can talk about it, we can counteract it, but let's pay attention. This is actually a bias. It has such a strong impact. It's also a great influence persuasion technique, but it also is a bias. The benefit of it is, we can show gain with it. So if somebody comes in at $1 million and now they're down to 200,000, we as mediators can talk about it to the defendant and say, look, you go to trial, they're asking for 10 million. Today, they've moved already to 200,000. That's a pretty big gain. I don't know, you want to use the word gain because that's kind of not colloquial enough, but I'll leave it up to you how you're comfortable talking about it. All right, so we're going to switch our focus for the last 20 minutes of this, and we're going to talk about influence and persuasion. So look, as mediators, we're trying to get people to do what we want them to do. And if you're negotiating without a mediator, you too want them to give you what you want to get. So this is a phenomenal book, Robert Cialdini. It's Influence, Science, and Practice. Lots of mediators have read it because we're in the influence business, but I would say most professions are in that business. You're looking for influence, be it personal relationship within your work environment, outside as you're negotiating with contracts or other lawyers, whatever your job may be. But this book is a bunch of social science experiments, and they looked at that to determine how people can persuade others to make decisions they ordinarily wouldn't make. Marketers use it and they capitalize on predictable buying patterns, and we can use it in the context of mediation and our negotiations as well. So let's jump into it. It's Robert Cialdini. I highly recommend this book. I love John Barg's Unconscious Influences book as well. I mentioned earlier, that too is about how do we get people to make decisions by tapping into their unconscious. So I think that's a great book as well. Likability is one of the main principles of this book, and it's very simple. The best way to achieve what you want and to get people to give you what you want is to make them like you, which is trust you, relate to you. So many times lawyers come into settlement discussion, they hate each other, they've been very rude to each other. Now your clients are already in disarray, so I always tell lawyers it's good to play nice and respectful because they'll give you more of what you want. And I see it in mediation when they like the other lawyer and the other lawyer's evaluating a case this way or representing what the evidence shows. They believe it. It's very beneficial. 98% of cases, 95 to 98% of cases settle. You should posture as a lawyer your case for settlement and get the other side to like. As a mediator, I do this all the time. I'll bring say compliments that one side may give the other. I'll say the other side's not putting you down in that way or attacking you. Actually, they've been very complimentary, or they're relying on this, or you all agree to this set of the facts. So I'll very frequently talk about what they agree on and convey all the positive that I can possibly convey between the lawyers with the clients. I appreciate concessions. Thank you. The other side's not here to appreciate it. They have me judge some negotiating academies amongst law students. They're really good at it. They're face-to-face negotiating. They're saying, thank you so much for this move. And I really wish I could give you more money, but I can't. And I hear that you're interested in this. How about I give you this? I think I could get you this. They're very appreciative, very respectful, letting the other side know they've been heard. It's an excellent strategy if you don't have a mediator. If you have a mediator, we're doing it for you. So we have to do that. We're connecting, we're building trust, rapport, we're making sure they like us. Initially, the studies were done in the context of Tupperware sales. They had Tupperware sales ladies, and they found that the women bought much more Tupperware from the Tupperware sales woman that they bought the Tupperware from. and when they liked them. And so that they've now studied in a lot of different other contexts. But it's true. People give more. I see it all the time in the mediation. So this likability concept is very important. Us mediators need to keep that in mind. And if you're negotiating without a mediator, you need to keep that in mind as well. People give more to people that give them information. The more information you give, the more likely they are to comply. So when we as mediators are trying to extract concessions, we need to deliver information. So a big part of mediation is information management. If we learn this in law school, you don't give 1,000 pieces of information or 1,000 pieces of arguments because they'll just focus on your weakest argument. We want to parcel it out slowly. So I manage information for the lawyers. If they're not doing it themselves, I'll deliver information when they'll have the most impact. Or I'll deliver a little now, and when I'm trying to get my next concession, I deliver more. Think about this in the context, if you asked your neighbor to borrow their bike and you're not real close with them, they may be reluctant because they don't know you very well. But if you said, look, I promised my daughter I'd take her on a bike ride if she got all A's on her report card, and we were going to get ice cream and my bike just broke down and I have a lock, I'll lock it up and I'll bring it back in an hour. All that information is more likely that they'll comply with your request to borrow the bike. So that's the same in mediation. That's the same with disputes. That's the same when we want to get people to give us what they want and influence them. So information is our friend, and as mediators, we should be information managers. Scarcity effect, that people give higher value to things in low supply. So we can play with this. Time, it can be in low supply, and it provides a pressure. Not only does Robert Cialdini talk about this, but Chris Voss, he is a master negotiator. He wrote a great book, Never Split the Difference. If you take masterclass, he has a masterclass in negotiation. He also says, put time pressure on any offer or demand. Mediations tend to settle at the end of the day. Part of that's because you're out of time. Also, part of that is because of the process of mediation gets people towards settlement. Cases settle right before trial. The largest percentage do. A lot of that's because you're out of time to settle. You're now faced with trial. The other part of that is that's when people have survived dispositive motions, have expert discovery, have taken discovery, are ready to really evaluate a case for trial. But time is a pressure. So as lawyers, we should, put a time pressure on accepting an offer or demand. When I do a mediator's proposal, I hold it up open for a definite amount of time. If they need board approval, it might be a week, or if they need insurance approval, it could be a day if they need to sleep on it. But mediator proposals with some time, if they'll allow it, right? This is their process, can be beneficial. So keep time pressure in mind. Rule of reciprocity is a biggie. And that's because we are strongly socialized to repay a favor with a favor. And it doesn't need to be a favor of the same value. It can be equal or greater value. So the Hare Krishnas knew this early on, and they would go to the airports and give you a 5-cent flower. And now you feel obligated to give them a donation. And maybe it's $1, maybe it's $0.25, but it's typically of greater value. I don't think they're allowed in most airports now, but at the time, back in the day, they did. I've seen other charities send me return address labels and then ask me for a donation. That too is that costs probably very little to send to me and to manufacture. And now it's triggering in me a desire to give a donation. So marketers know this, charities know this, and many negotiators know this. So if you engage in generous negotiating behavior, the other side likely will feel obligated to do the same. If you engage in stingy negotiating behavior, the other side is likely going to do the same. If you give them something they want in a negotiation, they are likely to feel the need to repay. So let's say you're negotiating with you're in an office building and you need an extra office space. And the other side was really trying to get outdoor space to hold business meetings, but you're allowed the outdoor space is yours. Maybe you can give them, they'll give you the extra parking space, and you can trade that for access to your outdoor space on Friday afternoons for their staff meetings. So when you trade something of low priority value to you for something of high priority value to another, that will trigger this rule of reciprocity. And so us mediators, many of us know about this, and we're looking for, as we create creative settlements, looking to trade off priority of interest. If we are engaging in slow analysis, they're going to engage in slow analysis. If we're doing respectful communications, they're likely to be respectful as well. So we should know about this rule of reciprocity. We should capitalize on the rule of reciprocity and invoke it. When I was an early mediator, I wanted to go shadow a bunch of the successful mediators. So I went and shadowed this one mediator, and he, every time he went into a caucus room, would deliver a snack. He would deliver trail mix one time and then chips another time. And after a few times he delivered these snacks, I asked him why he kept bringing them food. And he said he was trying to trigger it, the rule of reciprocity. So he knew about it. Now, the studies show that, food, even though it's totally unrelated to asking the side to make a concession in a mediation, that it can have a triggering effect, even though it's unrelated. I'm not sure it works or doesn't in the food context. I know at ADR services, we give food in a comfortable environment and cookies and whatnot. So just keep in mind, you want to try to trigger that. We're going to be asking for concessions from them. So what can we give to them? What favors? How can we make this comfortable for them? Certainty effect, they did studies. Lawyers said they'd spend 80% of their funds to increase settlement from 95% to 100%. Not settlement, outcome at trial, from 95% to 100% chance of winning. This was in a survey. People love certainty. Great. Settlement is certainty. Let's talk about that. Let's trigger it. It's the same thing with this risk aversion. People rather not take a risk, have a sure thing over a gamble. So it is a cognitive bias of risk aversion. And it's also, Cialdini's talking about it as a mechanism, a principle to invoke to get people to give you what you want for persuasion and settlement. That's how persuasion and influence, that's how strong the impact of certainty is. Consensus social proof. This is basically people are compelled to do what others are doing. So we want to talk about what others are doing so we can get them to follow us to settlement. They did a study in a hotel room. They used to have up, please recycle your towels, it's good for the environment. When they changed that sign to say a majority of our guests recycle their towels, they got 28% more compliance in recycling towels than if it's just good for the environment. So they played on this idea of consensus social proof. People want to do what others are doing. So if we, as mediators, had a case very similar to this that settled in this range, we should talk about it. If we saw a comparative verdict and it was for a number that we can get them in settle, we want to talk about it. If we can talk about what others are doing, if we have a commercial landlord and what are other similar spaces going for, if you're having a landlord-tenant dispute, if you're looking at sale of property, what are our comps looking like? What are other people doing, essentially? And that can be very persuasive. So let's keep that in our tool belt. It's so persuasive. It's also a cognitive bias called bandwagon effect. That people make decisions subconsciously based on what others are doing. So here we see Cialdini talking about influence and persuasion with this, and we also see it as a cognitive bias. It's so strong. So if all your kids' friends are jumping off the bridge, we do have to worry that our kids would jump off the bridge too. So we just need to keep this in mind and use it when we can to our advantage in trying to persuade people towards settlement. Unity, we talked about this when we were talking about trust and rapport. Cialdini's talking about it too. People are more influenced by people they have something in common with. So mediators oftentimes will spend a few minutes connecting. Maybe your kids go to the same school, or you went to the same law school, or you're members of the same bar, or you are members of the same religious institution. You live in the same community. You like the same sports team. You like the same hobbies. All of that can help you build the trust and rapport necessary. Even if you're negotiating without a neutral, try to connect to the other side in some way. Spend a few minutes making small talk. And then frame language in terms of we and us. We should come up with a response. They've done studies on that as well. It gives the collaboration. It certainly would combat them fighting you in these cognitive biases where they're very defensive. We should we should come up with a response. I try to use we as much as I can in mediation so they don't feel like I'm against them, that they know I'm working with them, and that they can follow me towards settlement. So keep that in mind. My only caution is you don't want to spend so much time doing this. It does annoy lawyers. I'll ask, when they complain about a mediator or something, they'll tell me, yeah, this person spent an hour talking about themselves. So, be quick with this, maybe spend a little time beforehand, figuring out how you can connect. Commitment, consistency. People want to act consistent with their earlier position. So that's that cognitive dissonance. That's the cognitive bias, right? You don't want to consider information that's going to contradict what you already believe. And Cialdini notices it too. You never want to get somebody to admit they're taking a position different than they earlier took. Look for early areas of agreement. Look, it's so great. You're all working with the same set of numbers. You're all working with the same set of facts. You agree on this. You agree that the broker should have done more here. Whatever it may be, that keep this in mind. People are very uncomfortable being inconsistent with an earlier position. That was that vaccine analogy I gave early off in the lecture. All right. And persuasion is another one. Robert Cialdini talks about this in his book, Persuasion. I love this book, and I think the name's so clever. And this is basically that the psychological framework of a discussion at the outset will carry as much or greater weight than the actual merits of your argument. So we got to position the recipient of our request in a way that will make them more inclined to give us what we want. And let's talk about, all right, here we go. Sorry about that. Let's talk about some of the tools of persuasion that we can use. What happened here? Okay, here we go. Before asking for a concession or asking them for something, let's focus them on the strengths of the other side's argument. So people can, give heightened importance to what they're talking about at the time we ask for a request, and they can only focus on one thing at a time. So if we're validating this side, telling them we understand and collecting information to go back to the other side with, but we want to extract a concession, right before we ask for the concession, we need to change the focus of the conversation to the other side's position. What I'm worried about is this, or how are we going to answer this? And then you ask for the concession. So you don't want to be focusing on all the strengths of that person's position when you ask them to make a move. Speaking quietly. So this is another one that Cialdini talks about. He says people move towards things that are quiet, when you move towards something, you give it heightened importance. Chris Voss also says, use this calming late night DJ voice when you're negotiating. Cialdini says, talk quietly. I don't think it's a great technique to yell at someone anyway, because we want to, they sometimes get heightened emotions. We want to stay calm. But also, if we talk quietly, they're going to move towards us to hear. They're going to give more importance to what we're asking them for. Tethering a request to a quality someone would like to possess, also the studies have shown can have a lot of influence in getting them to give you what you want. So they did studies. Do you consider yourself adventurous? People who said yes and wanted to be adventurous then were more willing to try interesting exotic foods. We're more likely to sign up for the summer camp, things like that. In our context, it can be depending what we want. If we want them to take a job, get rehired. You could talk about how they're a hard worker. If you want an attorney to help you find a solution, you can compliment them on being so smart, and they have such great ideas and they're such a great problem solver. Whatever quality substantively you're trying to get them comply with, that you're trying to create some influence with, try to talk about that quality before asking them for what you want them to give you. Providing only one
time check.
Okay, great. Do I have a few more moments, or do you want me to cut it here?
A few more moments is fine.
Okay.
We're at an hour. We're over an hour.
Okay, I'll finish it up right here. So another thing he said, Cialdini says, to provide only one option for settlement or one option at a time. And he did a study in a camera store, and he found that many more cameras were sold when the camera salesperson asked a few questions and took a person to one camera to fit their needs. And if that camera wasn't the right one, then the salesperson took the person to a different camera. That was a much better sales strategy than opening up the floor and saying, here's our 10 best-selling cameras, okay? The same applies in settlement. Don't give them 10 options to settlement. Say, let's give them one option. Let's figure out what they need, give them one option. If they don't like it, and say, okay, well, how about we do this? And we'll tailor it to that. So that's another great strategy in getting somebody to give you what you want, one thing at a time. All right. Well, thank you so much for your time and attention. I hope that you found some value in all of this. I skipped a few slides. If you are interested, please don't hesitate to reach out to me. I have up right now my email and my phone number. You can call me, or if you have any questions to how to apply this to your specific case, I'm happy to help. I love talking about all of this. And thank you.
I wanted to, hello everyone. I am Ann Wolf, the Education and Events Director for the Contra Costa County Bar Association. And I wanted to thank Stacie for this great program. I'm so sorry we had to cut you short. I know you asked me to do that for you, so I really apologize to everyone. I know there was a little bit more, and hopefully we'll be able to get that information in some of the materials that you provide. I also wanted to thank, let everyone know that Stacie works with ADR Services as a mediator, and ADR Services is one of our sponsors for the spec this year, and we wanted to thank them for that as well. Thank you to Paul Verschoker, the CCCBA ADR section leader, for helping put this all together. So you are now all invited to join a live Q&A session with Stacie immediately following my announcements. So below the screen on which you are watching this session, there's a link that'll take you directly to the live Q&A. The materials and the evaluation forms for this program can be downloaded from this session page in the Files tab above the chat. Attendance certificates will be available after Thanksgiving. Check the FAQ tabs for how you can get those. If you're a CCCBA member, they'll end up in your member profile. And if you have technical difficulties, just check the FAQ tab on the main page again. And so now, again, Stacie, thank you very much. And we'll all join in and click the link below the screen and join the live Q&A session. I'll see you there.